Hello everyone, welcome again to my channel. I'm Debbie Olabisi. I'm a specialist protection advisor, a speaker and an author, and on this channel we focus on empowerment, lifestyle and finance. If this is your first time joining me, you're very welcome. I encourage you to look at the previous videos to bring yourself up to speed about what we've been talking about. Today, what are we going to be talking about? Something very important, and I'm going to be sharing with you what you should know about revoking a will. Now, what do I mean by revoking a will? It is very, very important as a will writer to know whether our client has a will previously and whether that will is revoked or not. It may not always be what the testator intends for a will to be revoked, and some care needs to be taken to ensure that actions are not taken which accidentally revokes a will. There are different ways that a will can be revoked. Now I'm going to share with you some of those ways that can inadvertently revoke a will. One such way is by marriage or civil partnership. As a general rule, a marriage or formation of civil partnership revokes any will that a testator made prior to that marriage or civil partnership under Section 18 and Section 18B of the Wills Act 1837 respectively. However, there are some exceptions to this rule. If it appears from the will and at the time of the will was made that the testator was expecting to be married to a particular person or form a civil partnership with that particular person, the testator intended that the will should not be revoked by that marriage or civil partnership, then that will not be revoked. Now, it is also sometimes unclear whether a will can be written in anticipation of either a marriage or civil partnership to a particular person. For example, a couple who wish to formalize their relationship but currently have not decided the exact form. Neither the Marriage, that is the Same Sex Couple Acts 2013, nor the Civil Partnership Opposite Sex Couples Regulations 2019 include provisions relating to this, and there has yet not been any case law to verify this situation. The conversion of a civil partnership to a marriage does not revoke a will. A void marriage, that is, a marriage that is unlawful or invalid, an example would be if one party was already married, also does not revoke a will. The dissolution or annulment of a marriage or dissolution or annulment of a civil partnership also does not revoke a will. It will only cause appointments of the former spouse or civil partner or gifts to them to fail, as if the former spouse or civil partner had died at the date of the marriage or civil partnership was dissolved. Now, this area is really very important. I've found in my conversations with clients, sometimes you find couples, they've been separated for a couple of years and then one of them dies. Separation is not divorce. If you are not with your spouse or civil partner, my recommendation is just get a divorce and dissolve that union. If a union remains undissolved, it's still valid, and at the end of the day, what you want for your estate may not be what will happen. Something else that can cause a will to be revoked is the existence of another will or a codicil. Under Section 20 Wills Act 1837, the whole or any part of a will can be revoked by another will or codicil. What do I mean by this? This would normally take effect by including a revocation clause in the will, revoking all previous existing wills. A testator may have a will dealing with foreign property so that they do not wish it to be revoked. In such a case, the revocation clause can be restricted so that the averring wills are not revoked. Another way is in writing. Section 20 Wills Act of 1837 also allows for the whole or part of a will to be revoked by some writing declaring an intention to revoke what is executed in the same manner as a will. The final method of revoking a will provided by Section 20 of the Wills Act 1937 is that a will can be revoked by destruction. What do I mean by that? Destroying it by burning, tearing, or otherwise destroying the will. 2. By the testator or another person in their presence and by their direction. And number 3, with the intention of revoking the will. All of the above is present. If one is not proven, the will could still stand. For example, the accidental destruction of a will by the testator is not enough to revoke the will, as there could be no intention to revoke the will present. The destruction should be full. Only destroying a part of the will has the risk that the parts not destroyed could still stand. What do I mean? Tearing just one page of the will will not destroy it. Writing on the will or crossing out words is not sufficient to revoke it. It is preferable for a testator to revoke his will by some form of writing to ensure that there is actual proof of the revocation. I hope you've enjoyed watching this video. If you have any questions, I'm happy to answer them. Please post your comments or your questions, and remember to click the like, share and subscribe button. I look forward to shooting another video for you. In the meantime, do have a blessed week and see you next week. Cheers.